City, City of Newcastle Board of Adjustment training this evening will bring, we can have the, attendance, please.
Robert Irwin.
Jacinta Scarpetti.
Valerie Leary.
Angel Ramos.
Steven Zor.
We have, City Solicitor Max Walton and City Administrator Antonina Tantillo present as well. Mr. Walton.
Thank you. So, thanks for having me in. So some may know this, but I do this class, have done the Board of Adjustment class at the University of Delaware for the past 20 or so years. So let me teach it. So this is a modified version that I put together for everybody. Mayor, I heeded your comment. I think you sent a note to me or maybe to others that says you wanted to know a little bit more about land use just generally.
Well, just to define property rights, because some people think we can tell someone to keep their land green space when they've bought it.
So I added some slides in here that are in my normal Board of Adjustment, and let's go to the first slide. So I always tell people that the most complicated, there's three most complicated areas of law. Patent law, because you gotta know a lot of science, and a lot of other things, right? Insurance law, because believe it or not, you can have up to 100 insurance policies that may cover a given loss, especially in a catastrophic loss and all that, and land use. And the reason I say land use is because there's so many variables that you may not even think about, right? So we start off, and this is a slide I use in teaching Intro 101 for land use, right? You have to go to the United States Constitution. And why is the United States Constitution important? Because we are not allowed to functionally violate somebody's constitutional rights. And you all say, yes, I would never violate someone's constitutional rights. What about the rights to free speech? What about the right to equal protection? If you grant a variance for one person, it's the next door neighbor, and that person's a pain in the butt. You don't grant it, it's exactly the same one. That's an equal protection violation. And just, this is real. So we all know what is now the Hope Center, the hotel there. That was a case where the developer went in and they built it too big. There's a question, but they built it too big. They built it too much square footage. It didn't match the filings. There was all kinds of mess that went along with it. So they made a case that said, hey, the Newcastle County Board of Adjustment has granted 8 other similar variances. Hello, the Newcastle County Board of Adjustment has granted 8 similar variances, but they didn't grant ours. So it's an equal protection violation because they didn't grant it. And they wanted $8 million. And they took that on appeal, and it was reversed on appeal because the comparators weren't the same. But it gives you an idea, that's a case where the Board of Adjustment's actions were implicated in a constitutional violation. It's very hard to do that, but that's what it is. So you have to know the Constitution. You have to know the state constitution too. And everybody thinks the state constitution is exactly the same as the federal constitution. It's not in certain areas. For example, Second Amendment. The Delaware Constitution protects the right to bear arms more broadly than the federal constitution. So where might that come in? Well, if you're a board or a municipality, right? You got to know that if somebody wants to have a gun shop and the regulations that go along with that, we mix in things like adult entertainment uses. So if you think about that, that's deemed to be First Amendment because it's speech in theory. And there are a whole lot of cases about First Amendment and municipalities not granting, in your case, a special exception. So there's a lot of constitutional stuff. Then you have the state code. And for you guys, it's really, and we'll go through this, Title 22, Chapter 3, Subchapter 2, Board of Adjustment. But there's all kinds of things within the other pieces of the code which you may not know about, right? So if you go to that same chapter, Chapter 7, which deals with the Planning Commission, there's a requirement that says no development is permitted except in conformity with the with the comprehensive plan adopted by the municipality, and no development is permitted except in conformance with the plan. So there's some, and I'll go through the case law, but there's some case law about this. And then there's all these weird spots where they tuck in things about taxes and you go to Title 30, like it's all over. So it's very complicated sometimes.
Max, if you allow me just to interrupt for one moment, just for those who have just arrived, even though one agenda said 6:30, the time was actually 6 o'clock. So 3 of us were late getting here. So that's why we have already started.
And we've only gotten to halfway through the first slide. So
Yeah. Now,
this is
do
the
we
Board of
need
Adjustment.
to, this is Board of Adjustment. So do we need to allow for public comments before we continue?
No, we're gonna have it at the end.
Okay, all right. Well, I don't want Dwayne to sit here through it if
No, just your public comment.
he was concerned we might be speaking about
Okay.
the issue.
By the way, anybody, I don't care if it's anybody in the audience has a question, I'll answer. All the
So
way
if you
through.
have, if anybody has questions.
I am not trying to do this, so I'm gonna try to keep it to right about an hour.
Okay,
But, so then you gotta go to the charter, and Lord knows your charter is a little odd. I think it's old and bolted on in places. There are requirements in the charter, I didn't come up with a specific example, and they have to look at the ordinances. Why is the Board of Adjustment called the Board of Adjustment? Does anybody know? You have the authority to adjust the zoning code that's been established by the municipality, right? If I want a variance from something, and if I have a 10-foot setback in the code and I want a 5-foot setback, it gives you the ability to adjust the code. That's why it's called the Board of Adjustment. And so you look at the zoning code, but sometimes the zoning code isn't the be all end all. And then you have resolutions. And sometimes you can be directed by council in a resolution to do X, Y, or Z. And while that may not have the force of law, sometimes if you make a resolution, it does. I litigated for 10 years over the Newcastle County Southern Sewer Service Area, which was established and then withdrawn by resolution. So you gotta be careful, all right? So let's go 2 slides over.
our
Right.
charter has been updated. I forget what year it was, but it used to be written such that if you go down to the corner post by the well, under the tree, over to the X.
You're not the only one out
Yeah,
there.
so, but
So-
it's still, I get it.
So one of the things that we have not done, which is a requirement under the state code to do, is the Board of Adjustment files state code, you're required to adopt rules. What do those rules say? It's who goes first, who goes second, what happens if there's a tie vote, that kind of thing. We're gonna get those together. It's been on my to-do list for about 6 months to get something together for you guys. I just haven't finished it, right? Mayor, you can compel testimony. I've never seen a chair being able to issue a subpoena to compel testimony, but you have that authority to compel testimony. I did see it once tried in a case called Traders Alley in Newark, but it was ultimately unsuccessful. You gotta keep the minutes. We have great minutes. I use them to do my decisions, right? And the biggest thing you need to know about this is that when we do decisions, the mayor knows, I write up decisions, I use your minutes. Take those minutes, I take them with what I have in my notes and my memory. I try to put them all together, try to add the standards that we've discussed. You guys know I'm a stickler as the standards, I'm always asking questions, try to put it all together. That is not official, even after the mayor signs it, it's when it's filed, so that's why it's not filed in the Office of Board of Adjustment. You know, there was a case out in Belmont 20 years ago, but they didn't put their Board of Adjustment, didn't adopt it correctly. And they had no office that was the Board of Adjustment, they didn't have a filing cabinet, they didn't have anything, they have any. So guess what? Somebody got to challenge the Board of Adjustment decision probably 3 years after it was granted because they didn't do it correctly, right? So that's why if you look at every one of those decisions, I say date of decision, date filed, and that's the date that the mayor comes in and signs it and we file it. You have 3 generalized powers. Your appeal to the administrative official, your special exceptions and grant variances. So I don't think we've had, since I've been here, an appeal of something, but the appeals are always difficult. Let's assume, just for a minute, Jeff Bertram comes to me and he goes, I need some help with a code interpretation. Oh, and I had one the other day, and he goes, help me with this code interpretation. I said, all right, here's the way I read it. Well, then what happens is somebody does it and he says, okay, and we write it up, we send it out to the developer. Well, as soon as we send it out to the developer says, you got it wrong. And then there's an appeal. And that's taken from Jeff's decision that comes here. I am not your lawyer in that circumstance. We gotta get somebody else to come in and represent the board. Because I can't be judge and jury, represent you over something I helped Jeff with, right? And it's just the perils of being a solicitor. That happens, so that's when we would have that. So what's your role? You guys are judges, right? And I took this quote and I have it in there. It's from an older case. The Board of Adjustment, like Caesar's wife, should be above suspicion. I mean, you shouldn't be talking about applications the weekly or to the News Journal, right? Makes sense. You shouldn't be out there talking to your friends. You shouldn't be writing emails to people about it. You guys are here to judge what happens, right? And if you are advocating for one position or another, or if somebody finds out, right? So here's what some developers do. We haven't had this, but it happens. They try to pick people out and see who they can disqualify because they think you're going to vote against them. So what do? They go in and FOIA all of your emails, see everything they've said about it, and they try to come up with a disqualifying interest because they think you're going to vote against it. We haven't had that yet. All of our applications, but here's the point. If you're me, don't make me make that call that you have to disqualify yourself. Just don't say, think it all you want, knock yourself out, but do not put yourself in that. But to prove it's a judge, right? You've heard of immunities that are given in law for constitutional violations. You have something called a qualified immunity, which is, you can imagine, it's not an absolute immunity. You guys have judicial immunity, which means you act like a judge and you get an absolute immunity for certain actions. So that's very nice. The likelihood of anybody being successful in suing you in your individual capacity with judicial immunity is very, very low. You would have to do something like bribe somebody, or it'd have to be like over the top. Okay.
I have a question. So as far as that, just so that I have an understanding, because so my opinions or my personal opinions towards a developers doing one thing or another, does that go out the window while I'm sitting on this board?
Yes. Okay. And here's the thing. Let's assume we have a developer that had 2 projects. Okay. And let's just call them apartment, because that seems to be the thing around here, right? So the developer has 2 apartment projects, right? If you went over to council when council was going to approve that, you said, I can't stand this developer and I can't stand these apartments. Okay? When the next one came before you, that developer is going to say, you have shown impermissible bias because you've said you don't want apartments and you don't like me. They would probably be right. You have to recuse themselves. So this shows my misspent life, but I can tell you about cases, and I'm going to go through some cases today, but there's a case called Makes v. Board of Adjustment. It's out of Dover. And a lady on the Board of Adjustment said, I don't think we should ever grant this type of variance. We should never grant this type of variance. Something we just shouldn't do. And the court held that was an impermissible bias because what's your job? Your job is to make adjustments to the zoning code if they meet the standards. They said that was a bias. So you have those. I will tell you, most of my job is going into different municipalities where usually there's a circus going on or some development projects. And they asked me to represent the planning commission, the board, the commissioners, the council on that issue. The number one thing where they err, and if you notice, I kind of do the same thing every single time. The number one error is not following the prerequisites that are in the code. So if you have to put up a sign, that's why I keep asking you for the pictures for the sign. So I put them into the record. I try to look through what those requirements are, right, for everyone. And if I just put them in the record, you see me do it at the beginning. I'm like, this is going to be marked Exhibit 1, Exhibit 2, Exhibit 3. That way, if somebody decides to challenge you as to that, I don't have to come up with that later because the court looks at the record that's created. So I know I got notice covered. I got all those procedural mistakes. And you know what they get, Sean? I'm putting it in the newspaper 15 days in advance. People try to get away with it. I was down in Smyrna one time, probably 8-9 years ago. And I got hired the day before, and I was busy that day, and I go down there for the hearing, so I get down there, it's let's say it's a 6 o'clock hearing. I get there at like 4:30, I'm like, give me the file, I'm making my thing, I've got their code, I got their rules. Newspapers, 14 days, that 15 days. People are filing into chambers, they are piping hot, developer, like Sean does, he's got 1,000 attorneys with him. You understand, like, it's one of those deals. He said, sorry, we only gave 14 days notice. And we have to give 15 days notice, so we're all gonna have to come back. I'm the most unpopular person, because everybody who hates it hates me.
Is that 15 business days?
15 days, whatever, I don't remember.
15
15
period
days.
days?
That's
period.
your code requirement, it's 15 days.
Okay.
Some places have 15 business days, some people have, it doesn't matter, you get rid of that requirement, it's not a state code requirement, that's a Newcastle requirement. Going back to our initial one, right? We have requirements that are from the states, we have requirements that are from. So, this last line is something that's really left over from when I was doing a lot of virtual meetings when we were doing COVID and stuff. You sometimes get in a rhythm to where you get into a conversation, and we all do it. You guys do it sometimes. I've seen it. Make sure for the record purposes and for your purposes that we identify who that is. Okay, that's a big thing. Next slide. You're not bound by formal rules of evidence. You're not required to allow cross-examination. We haven't had a real heated hearing yet. You have to give an applicant sufficient time to make a presentation, but you don't have to give them 2 hours. You give them 1. You've seen me go, I told you 1 hour. I don't have a rule that I can enforce right now, but that will be part of our rules when we do it. You got to get your presentation done in a given time, okay? And you guys know what hearsay testimony is. That means it's not direct evidence. It's what somebody else might have said, right? At the end of the day, you can allow hearsay testimony, but your decision has to be based upon evidence. So if somebody stands up and says, Antonina told me that you're taking bribes under the table, hearsay, right? And you say, we deny this variance because so-and-so is taking bribes under the table. Well, you're relying on hearsay evidence as the only basis for what you're doing. You have to have actual evidence. And if you got to that point, you gotta know I'm not a shrinking flower. I mean, I'll say something. I'm not gonna let you do that, but just so you have in your head that you have to present evidence. It's an evidence that I'm holding this phone right now up in the air. It's evidence that I'm sitting in this chair. That's a fact, right? Something I've personally seen. So you gotta have facts. You don't have to read out all the letters when you get them, but if you have a hotly contested one, you get lots of letters. I know council reads their letters. Not a practice I'm a fan of, but nonetheless, we had a discussion. That's what council wants to do. You're not required to do that. It all becomes part of that record that I was telling you about, okay? And you're great at this because you lay out the statutory fact. You do a really good job, right? So your deliberations allow us guide, right? So while he's taking notes, I'm writing stuff down or I'm remembering things, right? And sometimes maybe the record isn't quite as good as I would like when I finally hear the tape. I can supplement that by things that happened earlier a little bit, but there's decisions out there that says that the board attorney can't just wholly rewrite and provide the whole thing. I gotta base it upon something that happened there, right? And again, you have to file it in the Office of Board of Adjustment. So I wanted to talk about area variances, and while we've discussed area variances quite a bit, what is an area variance? I mean, you guys know, really? It's literally, it's a question of geometry. I'm allowed to build in this space to this height. If you think about it, it's a box. I got a front yard setback, I got a side yard setback, I got a rear yard setback, I got height. Well, I want to do something that infringes on one of those rules, right? That's what it is. If you think about it, parking variance. If I get a parking variance, the rule says I gotta have 10 parking spaces, just like we did for the church the other night. I'm gonna have X number of parking spaces. You're granting sort of it's an issue of geometry. In that case, is the distance between that for walking to get the people from one parking lot to the other. So that's the area variance. There's also something called a use variance. Your code doesn't allow it. So I'm just gonna, I didn't include slides on it, so I'm leave it. That says a use variance says you can do something that at the property for a use that's not permitted by the code. So in other words, I have a parcel that's zoned residential. You can apply for a use variance, at least under the state code, that functionally says, hey, I can put a gas station there, and you guys could theoretically bless that. Well, there's two problems with that. Number one, your local code says you can't do that. And number two, it wouldn't be in conformance with the comprehensive plan, so you can't do that either. So I didn't include use variances in here. If we get something that smells like a use variance, I'll give you training on that, because this test is so hard. They have to prove that the property cannot be used for any reasonable economic use, which is virtually an impossible standard. There's been, I think, 2 use variances granted in Newcastle County outside of the city of Wilmington in like the last 10 years. It's just something that doesn't happen. So I didn't include it, right? But you guys get to relax the code or change the code, right? And this is from a case. It says the general principle that zoning boards and commissions should not liberally grant variances. What they mean by that is, and I'm just gonna call it like it is because I've seen this all over the state. A lot of times people just don't care, right? In other words, the neighbors don't care. There's nobody jumping up and down. It's like a reasonable use. I had one that I had in a municipality one time where the guy came in and says, well, he says, I gotta put up a lot of fence, and your fencing requirements are really, really kind of caused me to build an expensive fence. And it's gonna cost me $50,000, and I've been remodeling this house. And if I go with whatever other material, wood instead of steel or whatever it was, my fence is gonna be $20,000. And the board said, yeah, we'll grant the variance. You can go with the other material. That's fine. There was no basis to grant that variance. Like, I had to write a decision knowing that if it was challenged, we were gonna lose. But they granted it. And sometimes you might not care, right? Like, so there's things like, it's a judgment call. And I'm not passing judgment, but a lot of times it's easier to grant a variance when there's nobody here getting mad about it than when there are people getting it. That's human nature, right? That's just the way the world works, okay? But when it comes down, and those cases are kind of easy because you're probably not going to get challenged, right? But always remember, it's the applicant who has the burden of proof, and it's they have to meet the test. And you notice there are times when I help the applicant. Like, I ask them questions. Why do I do that? It's not because I give one rat's anything about their project. I don't even know where it is. I don't know anything about it, right? But if you decide to vote in favor of it, I need to make sure that I've gotten out of them the facts that are doing it. And sometimes even attorneys, as you guys have seen, they look at me like I have 2 heads when I start spitting out the test, right? And I got to draw that out of them. So it's their burden of proof. Well, here's the thing. Let's say we have a project that you guys all think is terrible. Right? All think is terrible. Well, this is, God forbid, but the only person here is the person who's giving the evidence. And there's nobody who stands up against it. And there's nobody there. Guess what? You don't have a record to rule against that if they've met all of the factors that you may think is terrible, right? But then you got to work real hard to try to get a bad fact out of the one individual because you have to judge it based upon what's in front of you. Can't judge it on what's your own head, right? Like you can't say, oh, I drive by that every day. Yes, you probably do drive by that every day, right? But you have to have the evidence has to be what's presented on the record. So if you drive by it every day, and somebody did it the other day, I can't remember, been to a lot of places lately, but I think it was here. Somebody said, did you do that on a Friday, like a traffic thing? Do that on a Friday, right? And which is a perfectly fine question, right? And so you got out of them what you needed to get out of them, what you had in your head that you saw it. But if you hadn't done that and you'd have just waited and you'd have voted the other way than you actually voted, and you said, I know because I'm there, I see it every Friday and there's nothing in the evidence. That would have been an invalid vote, right? Because you have to do it based on that. But remember, it's always on the applicant to have the burden of proof, right? And this isn't a place where we have like some places have like a planner or a building inspector or somebody present and they have a side and that kind of thing. We don't tend to do that, nor have I seen a need to do that. Generally, I'll do it if there's something I think I need to introduce. Again, I'm not a shrinking flower. I'll stand up and I'll introduce it. And you'll see there's lots of stuff in your code which we can get an appeal on. I'm not gonna try to go through all that stuff today, right? There's all kinds of things. The quick check factor, not gonna take long. There they are. Most important thing we need to go through. I don't judge them on the left and on the right. Right? If you meet the nature of the zone, the character of the vicinity, right? The use and effect on the property, those three all go together. The big thing is, you heard me say it, exceptional practical difficulty. What does exceptional practical difficulty mean? Well, we're gonna go through that because there is no definition. There are, and I'm gonna go through these quickly. There are certain terms within your code that are just a little bit different, and let's go to slides number 13. All right, and I think the most important one is number 3, that the special conditions and circumstances do not result from the actions of the applicant. What do I mean by that? Well, there's a slide on this, but let's assume just for a minute, I'm a Newcastle resident and I go out and I start building a shed. Right, and I build a shed and I'm not supposed to build a shed and it doesn't meet the code or whatever happens, right? I pour footers, I'm halfway up. Jeff goes out there and he goes, you ain't supposed to have a shed there. That violates the setbacks. Well, in most places, you can then come to the Board of Adjustment for a variance. Like you could have gotten a variance like sort of after the fact. Your code, for whatever reason, does not allow you to do that. In other words, to grant an after the fact sort of variance, right? So I think that's the biggest one under these. We haven't had that provision come up. I've been aware of it for a couple of months, but we haven't had that, right? But these terms, and maybe when we do the rules, I might incorporate some of these terms into our standard thing. I could probably do a better job of that, but I haven't had the need to go to these so far. So, but I just wanted you to be aware of them. So on slide 14, if you think about it, everybody who's coming before you has a practical difficulty. Take my example of a guy with the fence, right? That was going to cost him $50,000. He wanted a variance for $20,000. His practical difficulty was he had to pay $30,000 extra, and he didn't want to pay it. That's not exceptional practical difficulty. That's just a difficulty. Anybody who's got to come in here has got an issue. So it has to be something more than issue. It has to be exceptional practical difficulty, right? And so I have searched my entire career for a definition under Delaware law on what constitutes an exceptional practical difficulty. And I have found zero. There's no definition. So what do? Is I try to gather up sort of examples of where the courts have found there to be exceptional practical, right? Must perform the evaluation by keeping in mind the public good and the intended purpose of the zoning regulations. Practical difficulty is present where the requested dimensional change is minimal, the change in geometry, and the harm to the applicant if the variance is denied would be greater than the probable effect on neighboring properties. And it says it has to be practical, but here's the one: difficulty must be inherent in the property. So I'm going to give you an example. It's from another state, and I learned it at some sort of conference I went to. But here was the case. Guy goes to the Board of Adjustment, and he says, "Look, I got this aging mother-in-law, and what I'd like to do is over my garage, I'd like to put an in-law suite, right? I'm gonna put in a little elevator, etc. And that's where she's gonna live." And he's like, we can't really afford to give her out. We need to keep an eye on her. So I want to do this. And the board says, yep, we're gonna grant you the variance. Well, lo and behold, he had a neighbor next door, and his neighbor was a kind of Hatfield McCoy kind of neighbor, and what did the neighbor do once he got that variance? He took him to court. He said, you didn't establish any difficulty practical to the property. You established difficulty practical to yourself. Your mother-in-law needs a place to live. You didn't tie that to the property. Court said, you're right, you reversed it. You always tie it to the property. It can be economically motivated. The prime example is the Brandywine transmission case. Brandywine Transmission wanted to, they're against a road and they had a setback. And they had 4 bays, right? Well, they could make more money if they could do transmissions out of 5 bays, so they went into the setback, right? So they wanted to do a 5th bay. And they said, that's economically motivated. You can already service 4 cars. And they're like, yeah, but we can make more money if we have a 5th bay. And we're gonna run our transmission business out of here. And that was said it was okay, right? So they're economical. So again, if you go to the next slide, that self-imposed hardship, most places, isn't a reason to deny a variance. Newcastle City and Sussex County, to my knowledge, are the only jurisdictions who have that rule, self-imposed hardship. Inability to improve one business, that's an exceptional practical difficulty, right? So additional expense, that's not enough. That's not enough. I have never seen the next one. Any variance can give rise to an unacceptable threat of injury to public health, safety, morals, or welfare. I've never seen that one, but it's in a case. So what is unique enough to get there to make it to the property? I think the best example was the guy who was up against a railroad right of way, right? And he had the tree that he wanted to save. Remember that? Like that was probably the clearest example of that, all related to the property. By the way, I didn't get that from the application. That's why we have hearings. So I was like, oh, like I was wondering what his exceptional practical difficulty could be. And that guy, well, wasn't trained, but did a very good job of explaining that that's was the issue. That's tied to the property. That's what we need. That's what we need. And you'll hear me say, what's unique about the property? You guys have seen me do this, right? Tell me what's unique about the property. What's your exceptional practical difficulty? So again, I'm not doing that because I care about what their answer is. I need to know what's in the record to make sure we have a record to back up whether or not you do it or deny it. I've been accused of being a little overactive, but I think especially when you have pro se people, I think it's helpful, to try to draw that out of them, because I don't want you guys to not have a record. If, let's say, you want to vote for it, you can't if they don't meet their evidence test, right? When I'm up here and representing the board, I work for you guys, right? So if you think I'm being a little overly involved, tell me, I'll shut up. But I'm trying to elucidate from those people. And the last thing we want is a Board of Adjustment appeal. And I'm gonna go back and I'm gonna show you Newcastle decisions when we get through here. It's of stuff that has happened and it's real, right? So we did, for the first time, at least in my tenure, special exceptions, right? What is a special exception? You're not adjusting the code in that instance. The legislature has already said, this is okay, but we want you to evaluate conditions that we put on the property, right? We want to make sure that the conditions are met, right? You have to create a record. That's why remember we were talking about, here's your, let's walk through there. Got to create a record, right? And you guys, and I listed, these are right out of your code in slides 18 and 19. We went through those the last time. I'm not going to bore you today, right? So you got to go through those, and sometimes with respect to special exceptions, like we had 2 different like we had the one guy at the church, right? He had no idea that these were in the code, because if he would have known they were in the code, he would have hit those in his presentation. And you saw him almost turn white when I said, hey, and I started asking questions. So one of the things we could do in our rules when we create them, suggestion is you can make people submit in advance while you meet the test. Right, so at least you have something that's in the record ahead. It's harder for a variance, but a special exception, you can do that. That's something that we might want to consider, sort of a checklist cheat sheet, something like that.
This would be provided to the applicant.
Yeah, so. The code says you have to have rules. We don't have rules. Bergstrom tells me we have rules somewhere, but then for the old form of Board of Adjustment, we ain't got no rules, right? So we're gonna have to, at some point in time, again, put together best practices. We're not talking a booklet, we're talking a page, right? Here's who goes first. Here's your time limits. This is what we need for a tie vote. This is what we want you to submit in advance. We don't, right? So there's just basic, so we're not. I understand that right before my colleague Chris Griffiths got here, and then I came in soon after, my former colleague, that you guys board was like the mayor and the city engineer and solicitor, which is the stupidest form of Board of Adjustment. And I'll tell you why it is. Reason it is because take my fact pattern. Jeff Bergstrom comes to me as the solicitor. I have this problem, right? Help me interpret the code. Okay, and then somebody appeals it. Well, every single time then I have to recuse myself. And then there's
Right.
only two people there's not enough to decide it, right? So I know that there are people who don't like the fact that they changed the Board of Adjustment, but this is so much better from a conflict perspective and an involvement perspective. Just can't have that. So I'm a big fan of what you did, but you as a board, we just haven't had a chance, right? To sort of pick through that. But you guys are really getting your groove. Like I use you guys as an example of a new board who does a very good job at laying out like your facts and what they are and do a good job with testimony. This is not being critical. I'm just saying I think we need to take the next step. So I already told you that if Jeff comes to me and we do a code interpretation, like I did the other day, if somebody appeals that code interpretation, you guys are getting a new lawyer and I am gonna be on Jeff's side, just so you're aware, because that's the way it's gotta work, right? When there's an appeal filed, it stays the underlying decision, right? And that sounds weird, but like there's no enforcement that can go on once that appeal is filed for the board, so you guys make a decision. So, and when you're doing an appeal, what are you doing? You're doing an interpretation of the code. That's not what you think. There are rules that sort of lay this out, right? And you construe the statute in a way that will promote its apparent purpose and harmonize it with other statutes within the statutory scheme. Guess what? You read it the way it's supposed to be read, literal. But if you find that there's ambiguity, you could read it two different ways. A reasonable mind can view it two different ways. The courts, in what I consider to be the dumbest rule ever, but it's the rule and we have to follow it. If there's ambiguity in a zoning code, it has to be construed in favor of the free use of land.
It's construed in the favor of.
Free use of land in
Free
favor
use of
of the
land.
property owner. Okay, the free use of land controls. The good thing is on that appeal, you'll have to have your attorney who does the appeal explain that to you, but that's the way it has to be. Now, I have, and I'm going to write before the end of my career, a law review article saying why I think that rule is wrong, but I haven't gotten around to it, and until the courts change it, that's what the rule is. And I'm not here to tell you what I think the law ought to be. I'm here to tell you what the law is as it stands right now. I know Mayor and I get into it a little bit of while, every once in a while about that kind of stuff, right? So, and that's just the way it is. I just try to call it what the law is right here today. The best of my, I don't have to like it. I certainly don't like this rule.
Right, but we're reading sometimes the same thing and you just have a different interpretation and I'm like, but it says this, because I'm rather literal too, so.
We can have our disagreements. Maybe that's when it's ambiguous. We have to do it in favor of free use of land in that context. So, you guys are also the dumping ground for every other appeal in the code, it seems like, okay? So I didn't go into all of that. You guys can hear appeals for extension of a non-conforming use, there's provisions in the chapter, in the code about that. You act as an appeal board under chapter 141 for dangerous and vacant buildings. Haven't had one of those yet. You're an appeals from assessment of the building official. Haven't had one of those yet. And you also grant floodplain variances. You also have, and I don't think it made it onto my copy, you also have appeals from certain actions of hack. So there's a lot where you guys are the dumping ground as an appeal, okay? So when those come up, and wasn't gonna spend the time today because 98% of what you guys are gonna do is variance special exception. Variance 80% of the time, 80% of the time, special exception. That's what you guys are gonna do most of. That's what I'm focused on. If we get one of those other ones, you'll get a memo from me and say, this is how it works, and this is what we need to do. You guys have a lot of words in your code, let me tell you. It's a lot, because it's the longest sort of Board of Adjustment section I've seen anyway. I just call it like it is. But your code mandates that it's a majority of the members, which is kind of unique. Kent County has the same. So what does that mean? Let's say you have a quorum of 3 people. They hear it. If you guys go 2-1 in favor, it fails. Because you have to have a majority of the members, not the majority of the members present. Majority, that's why I bolded. Majority of the members, right?
Oh, I'm ready.
25.
Oh my gosh, I'm still ready, okay.
So, and there's also provisions in your code, which are very lengthy, again, that deal with failure to abide by conditions. And I'm gonna go through conditions in a little bit. So I've talked about the appeal being on the record, and I just wanted to give you 2 minutes on what happens if a board of adjustment appeal is done. I don't want to spend a lot of time on it. They come in, they file with the Superior Court, they say, you got it wrong, the appeal. There's a record put together, which is functionally the minutes. I gotta get a transcript from a court reporter, put all that together. It goes up to the court. All the exhibits that are put in, that's why I'm like, we're gonna mark this as exhibit A. All that stuff goes up to the court. And then once that goes to the court, then the court decides it based upon the briefs and the record. And so I guess my big takeaway is get something on appeal. Don't talk about it. Don't say that's a stupid appeal. Don't, just say, hey, court's got it now, and that's the way it is. So if you go to the 28th, the judge is never going to overturn your factual determinations. Like you guys make a factual reference. The tree is in the middle of the yard. Judge is going to do that under the substantial evidence test, which means not a preponderance. If a reasonable mind could support the conclusion, then the judge, even if the judge thinks differently or should have been decided differently, it's going to defer to your factual judgment as the finder of fact. And that judge is going to defer to you. Where does that not get overcome? There's a Board of Adjustment case, it's out of Sussex County, where somebody on the Board of Adjustments turned something down. There's discussion of crop dusting in the area and how if you had this use, it was going to do crop dusting. It was turned out conclusively that it wasn't going to impact crop dusting because it didn't have this buffer zone that this guy was talking about, which he was wrong about. That's he wrote it in favor because it's crop dusting issue. When crop dusting wasn't an issue, that didn't satisfy the substantial evidence test because he couldn't rely upon that. But most of the time, if it's a tree was there or this is going to be built there or whatever that is, you guys, that's a powerful thing because you find the fact. Now, if they think you interpreted the code the wrong way in an appeal or something like that, they're going to bang you. They're going to get you also if indeed you don't have reasons in the record for your vote. That's why I'm so vigilant about asking questions to know that, right? But the court's not going to turn it over. So I just go through here, and this is part of my regular class. Like, what are the pitfalls, right? It's basing it on crap that you didn't hear. When your vote comes up, and you're like, well, Fred told me, seen it happen many times. Fred told me that this happened and I believe it. No, you got to base it on the record that's there, right? If you have an appeal, don't be discussing that appeal with me or any of city staff, right? You're a judge. And if they have what's called ex parte contacts that you're not authorized to have. So let's say there's an appeal. I represented Jeff. You called me and you said, hey, I want to ask you about this appeal. I'm gonna go, talk to your attorney, because if we did have a conversation, then that would be ex parte contacts and you lose your vote. By the way, if somebody needs to recuse themselves because of ex parte contacts or otherwise, the rule in Delaware, if somebody participates and they should have recused, the rule is that taints the entire board and it knocks out the entire proceeding. That's the rule in Delaware. I don't like that rule either, but state of the record, don't have ex parte contacts. It's impermissible to rely upon personal site visits. This is Newcastle. You're gonna know what the sites are. That's okay. But you can't base it solely on that. So if you know that like, for example, I know one of the council meetings, the lady was talking about the church and the trees growing over the sign, right? Well, if you know that the trees growing over the sign, say, you can tease it out. Hey, is there a big tree over there? Can you tell me about that tree? You know what I mean? Just don't go, I know, that's a fact. No, you don't want to do that. You want to draw it out of the hat. The next slide is articulate the legal standard. You guys do a great job of that. Exceptional practical difficulty for variances. I just thought I'd burn through a few cases, right? And the first case, in case you guys want to look it up on me. This was a crazy case that went on about the H. Fletcher Brown mansion. And it says the Board of Adjustment cannot grant a use variance because the comprehensive plan has a force of law and it's the constitution of the municipality. Since we don't grant use variances, we're not gonna have that. Oh, wait, I misstated something. When I said that there were only 2 use variances granted outside in Newcastle County, that did not, and I remember I noticed Wilmington grants use variances all the time. If they ever get challenged, they get overturned. They grant them as a matter of course, but every other place they don't have them. Ultimately, the H. Fletcher Brown mansion case also said they had the type of Board of Adjustment where the mayor appointed, or the mayor sat on there, on the Board of Adjustment, who appointed a designee. So the first time they did it, he did it wrong. And the mayor was absolutely in favor of this redevelopment of the H. Fletcher Brown mansion. They said that was an impermissible bias. And the court said, even though the mayor appointed, and the guy he appointed was his chief of staff or whatever else, there was no indication on the record that there was any actual bias, and perceived bias was not enough. I will tell you that if we go before the Public Integrity Commission, they will find bias in whatever little tiny contacts you come up with. But they are that way. They find conflicts where I don't think there's conflicts. So in other words, just keep your nose clean and don't talk about it. So that's H. Fletcher Brown. Stingray Rock, right? That's where the guy said, the chair would always go in. And by the way, the chair in Newark for years saying, tell me about your hardship. Not the test. It's what's your exceptional practical difficulty? And that's what happened here at Stingray Rock, right? And as the Delaware Supreme Court said on page 35, the use of the proper legal standard by the board is a prerequisite for judicial review of the sufficiency of the evidence. And where the board fails to apply the correct legal standard, it's going to vacate your decision every time. That's why I keep going back to what's the standard. That's because you guys probably know I'm paying. AT&T court cases in here because it shows that the court, if you don't do it right, the court can actually grant the variance over your objection. A court has the ability. It's very, very rare, but that's what happened. Covington shows what weird stuff that you can get in front of you. It was an appeal of a determination that a particular application was governed by the pending ordinance doctrine. You know what pending ordinance doctrine is?
That was just like new.
Okay. Let me try to get it. So the pending ordinance doctrine means that if council introduces an ordinance, there's different variants, but let's just say they actually introduced it. And it says you can't have tulips in front of your house. And somebody comes in for a permit that they want to have a tulip garden, but the ordinance hasn't passed yet. The city has the ability to deny the application because the ordinance is pending until the council finally Does it make sense? So
Yeah, okay.
it's law before it's law, under the pending ordinance doctrine. So you can hear, and for no other purpose, Mayor, is to, the reason I bring it up is you can get some odd stuff. So the question that went before the board was, is this application subject to the pending ordinance doctrine? It's the only reason I include it here. So you can get things that are out of the ordinary. NEPA, and the reason I bring up NEPA here is that this case says that the state code is the floor of what you can do, but you can add additional requirements in your code. So for example, I told you that your code has this kind of odd provision that says your hardship can't be self-created hardships, right? But you can add other requirements, even though the state code would say that would permissive, you guys can narrow it. In this case, said you can add other things like no self-created hardship. And they said the municipality can add on to them. So the Colburn case, it's one of y'all's. And my partner Joe was on the other side of it. So the mayor said, the mayor like said, I believe we should agree with the building official and call the street. So the application tied 1-1. Well, that was an insufficient articulation of the reasons of the votes. And that got the case overturned.
What was it? What was, I kind of remember this one, but what, I don't remember what the final, what the decision was, it was a street or not a street?
It's tied,
Okay, so
Yes.
therefore it didn't pass.
therefore it didn't pass. So Davey, I'm going by memory and what my colleague told me. Dave Athey gave a long articulation of why it shouldn't be.
A street.
Yeah, and then the mayor said, and I think the building inspector, I don't remember specifically, somebody wanted it to be a street, somebody didn't. And whatever the building inspector said, after Dave gave his articulation to the other side, God rest his soul, then the mayor said, well, I think we ought to agree with the building inspector, and didn't articulate anything. And that was the end of it. So, but I don't remember this particulars. It's funny, I gotta go back and look at this because I got an email from one of the planning commission people about this. Issue, and I don't know what's a street or not.
So it resulted in a 1-1 tie where there are only two people. Gotcha, okay.
That's why I'm so happy you changed your form. I don't know who did that. I didn't have anything to do with it, but I'm super happy that you did, right? So just a couple other things. If you have an appeal, you have to have the property owner be a component of the appeal. So if we have developers in here, we have to make sure we have the property owners sign off, right? You can get a variance on some property, you don't know, you can be an equitable owner, like an owner and the developer, but you gotta have the owner's signature. Jack Lingo Management. And I include this case really for the bottom. Local governments are empowered to reasonably restrict property uses through zoning. When they do so, they must define the restriction in a clear and unambiguous terms. Again, what do they mean by that? If there's ambiguity, you have to construe it in favor of the free use of land. And this one was just decided, John DeMundi Enterprises in Fairview City. Was this under the old board or under the new board? I can't remember.
I didn't hear it, no, so it must have been the previous board, which would have been former Mayor Mike Caranta and
So there's lots of, they hope that he didn't have standing, the person didn't have the standing, but they also argued that if the sole motivation for a variance is economically based, then you can't grant it. And the court said, no, you can have them, but you can be motivated, fast forward, for whatever reason you want, if you meet the test. So the last one I promise on cases is the Michaud case. And this is the case I argued. So you guys don't have jury, what this case holds is the planning commission makes a decision of some sort. People might try to like come and appeal it over to you guys. Two things then need to happen. Number one, we learned from this case, you actually have to hold a meeting to say you can't do that, right? Because we just dismissed it. But two, we'd hold a meeting, say you don't have jurisdiction. But two, makes it very clear that you can't appeal a planning commission decision as a body of the city. You can appeal Antonina's decision to the board, you can appeal Jeff Bergstrom's decision to the board, maybe even my decision to the board, but you can't hear an appeal from the planning commission.
The planning is only a recommended.
There's a lot of weird stuff that happens out there, Mayor. I was just
Okay.
throwing out I was just throwing out, this is what the law is. You can't, because people sometimes do it. I thought that this is a whole nother class, I think, that I'm actually I've taught it once. I'm gonna teach it again. May come over here and give it to you. And I think I got it right, but I don't have it quite right yet. But takings are what's called unconstitutional conditions. And what is a taking? Taking is any time that you, the government actor, enter on the land, do something, right? And you use somebody else's land, private property, if you take private property for public use, you have to pay just compensation. That the amendment says. So even if I just have a temporary construction easement where I need to put some equipment or drive, you gotta pay for it, right? So a regulatory taking is a little bit different. That's a physical taking I just spoke about. Regulatory taking is when we, by code, deny one all or substantially all economic viable use of land. Let me give an example. I have a beachfront 1/4 acre property that's buildable. And the government comes in and says, well, we're gonna increase the setbacks on the beach from 5 feet to 100 feet. And once I do that, there's nothing I can build. It's a regulatory taking. You've taken away all or substantially all economically viable use of that particular property. So it's a taking. So a lot of times people come to you and you as a board of adjustment is the final decision maker, or they can bring a constitutional claim.
But the government has to compensate you.
Yes, and so many times, yeah, well, they should compensate you, but many times, because of the way the law is written, the reason I'm telling you about it is one of the requirements is they have to come to the Board of Adjustment for a variance before they can jump into court and get the compensation. So
The applicant or the government?
applicant. So look, we can't do everything, right? I gotta write the rules. The other thing, I'm not in love with your code. It's fine. I'm not gonna rewrite the whole thing. But the one thing I think you guys need to do as a protection, and you do protective things when you don't have the issue, right? You do it. But most jurisdictions that I've represented have all adopted something called a beneficial use appeal. And what is a beneficial use appeal? Basically, if the council does something that denies one all or substantially all economically viable use of the land, it could be by accident, right? But they didn't know, but they passed it. And they're like, oh my gosh. A beneficial use appeal is an appeal that allows you guys to grant relief. Well, like give them, adjust the code so we don't have to pay takings damages. It's an out kind of thing. So at some point in time, when I get some time, we're gonna write that ordinance because we really do need a beneficial use appeal for the protection of the city as a whole. If you ever heard one of these things, you talk about a pain for the board, it's difficult, but it does save the city a lot of money. So that's why I'm gonna recommend it. So the last thing I'm gonna talk about is, and this is the mayor, well, it's not the last, but one of the last, is exactions. So this is really conditioned. So if I go in and I have a development project, let's say it's a 100-acre farm field, right? And I'm gonna build 100 houses, their streets and all that stuff. Government can ask for stuff from you, the developer, like, give me 10 feet because this development's gonna require me to put in a turn lane on this road. That's an exaction, right? You're giving up property right there. That's a condition of a permit or approval. There has to be a nexus or a rough proportionality between that request and the societal issues that come with that development, right? So if you think about it, you gotta have a turn lane. It's okay to ask for the 5 feet. Classic example of one that's not okay is a guy, it's a US Supreme Court case, guy wanted to build a house on the beach. And then they had a permit and they said, all right, as a condition of your permit, we want you to give a 5 foot on the edge, a 5 foot pathway or easement to let the public come across, so there's another opening for folks to get to the beach, because you're gonna be building a house. The guy said, I don't want the public walking across my yard. No, and we can give them the permit. And they said, that's an exaction. That's an unconstitutional condition, because you have the right to exclude people from their property. And there's no sort of societal or sort of cost that goes along with that, because you're gonna build a house. So there's another one where a guy wanted to build a US Supreme Court case. By the way, it's the Nolan and Dolan test, and I forget whether or not that was Nolan or Dolan, but here's the other one. So there was a guy, and he wanted to build an extension to the hardware store. And if you can imagine, it was in a corner, there was a park that kind of came out beside, and then there was like a wetlands creek sort of area, which he owned up to the creek. And they said, I want to expand my hardware store. And they said, okay, well, then we want a conservation easement and a donation of land to our park. And so we make sure that that creek stays pristine. He's like, why am I gonna give you all of that? I just want a permit to build my hardware store. Went all the way to the Supreme Court, and they said, there's no nexus or rough proportionality between what you wanna build, expansion of the hardware store, and donation. I'm putting a conservation easement on this place. Now, I didn't go into it all that much here, but I have a whole class that I teach on this. And there's another case called Kuntz. And Kuntz stands for the proposition that if your mere demand of a condition is unconstitutional, not that you got it, not that you got the thing, not that you got the easement, not that you got the whatever, but if your demand is unconstitutional, then you owe takings damages to the developer. And this whole idea of exactions is a very hot button issue. And what happened in that case, the case was the weird Florida regulation, but it's to fill wetlands, and he wanted to fill 3 acres and have, I'm guessing 12 acres that were protected by an easement or something. They only wanted to have 1 acre. There was a big dispute, etc. They said the mere demand for the 1 acre provision, and they only let him build on, that was an unconstitutional condition. They hadn't paid damages. Those damages are, I don't know. I'm not gonna let you guys walk into a unconstitutional condition. Sometimes, I've seen it many times, because I've been doing this a long time. It's hard to believe how long I've been doing this sometimes when I wake up. Is people get into it, says, well, there's no problem in me asking for the moon and then negotiating backwards. That is false in this context since 2016. I'm just telling you, you have to ask for that which is reasonable. And this is one of the very few places in the law where the burden is on the government to justify its ask or its demand. It has to be reasonable. I'll tell you where it comes up a lot. A lot of times codes, I'm sorry, I don't know if you guys have this or if you don't have this, but I know of codes that have it. So sometimes they have open space requirement is 10%, but you can pay a fee in lieu of open space, and you can basically buy that parkland, so that way the city gets to use it somewhere else. Well, if that's not reasonably proportionate, guess what? That's an unconstitutional condition. That's where it's come up a lot, where people have to buy out of stuff. So it's an issue. And the Supreme Court just screwed it up, in my view, on sort of how to interpret that. But if I see you guys going down the road, and I was like, I don't need to get up, you will never get to the position with me unless I'm asleep or something, where you guys will get like halfway through the ask and I'll cut you off. Because once you get through the ask, we're toast, right? Because you already demanded it. So I'll probably cut you off. So you ever seen me come out of my chair? I don't do it often. You guys, I think you know me well enough what my style is. So just a couple other things responsive to the mayor's sort of issue. And I think this is what you start with. If you have a subdivision that meets all the requirements of the code, the council has to approve it, right? Just like if you got somebody who comes in here and they meet all the tests for what they need. Again, you guys may hate it, but nobody's here to object. And that's the evidence that's in front of you. I'm gonna have to prove it, because that's the way it is. Now, you can place conditions on it. They have to be, again, they have to have a nexus or rough proportionality to it, right? Again, they have to pass the exaction test, right? And the last one is, and we don't do enough of this, and I'll take some of the blame. Go back and look at the comprehensive plan on certain applications to make sure that there's no conflict. Comprehensive plans for municipalities like the city of Newcastle. The entire text and maps have the force of law. The entire text and maps. Newcastle County, it's only the future land use map that has the force of law. So they can put in their text whatever the hell they want to, but you guys are bound by the text. You know, what's written in there. That's why when I go through comprehensive plans, I'm like, there's a lot of aspire to do so. It's never a part of a certain command. So that's as best I could do, as fast as I could do to give you the most complete Board of Adjustment training that I could. I hope you've got something out of it. I'm certainly happy to answer any question.
So under, and I mean, I can give examples of things that either council has approved or Board of Adjustment has approved in terms of new building or anything else. And there's this belief out there that we can force an owner to do something other than which he bought the land for. So Lucas Drive, you know, people are like, why didn't we just keep that green space? We should have made it. Well, the owner of the land didn't buy it to create.
So if you made it
Green
green,
space.
if you made it green space, yeah, could you?
We'd have to pay them compensation, right? So,
Yeah.
yeah, well, I get that. I just want it heard. Otherwise, it's, you know, where some complexes come in for variances in order to be built, you know, we cannot tell that owner that you can't do something because we want green space when everything abides by what
If
we
you-
all just talked about.
If the development meets all the requirements of the code, council is bound to approve it. Period, hard stop. And sometimes there's a question of whether or not it complies with the code. I have that for Newcastle County right now. Where it's one, where everybody's all hot and bothered over whether or not there's a traffic impact study that's required in that particular case. I can't talk about it too much, but I mean, ultimately, council, Department of Land Use sent it to council and said, this is code compliant. They sent it back and they sent it back and said it's code compliant. And the council came back a second time and said, we don't think it's it's code compliant. And all right, it wasn't code compliant. I mean, there's a lot of regulations that go along with.
Well, one thing that came up for like the last one we did with the apartment, so somebody came out and said, well, we should have approved townhouses instead of apartments.
That's not what they asked for.
I know, but we as a board can't say, hey, you can't build apartments. I'd rather have you build townhouses.
Yeah, so here's the thing, right? Your job, the council has already established what the zoning is, whether or not it allows apartments or not. Or you could just have townhouses that they've set the district. Conditional use or special exception, they're exactly the same thing. Two different bodies done. You guys do special exceptions, go to the Board of Adjustment, conditional uses, which you guys don't have, go to the council. But the function is the same. They're already a permitted use. And what you then do is you apply a test. And so your conditional uses can be different. You guys have this really long list that we went through, right? But that list doesn't permit you to say you should build townhouses on that. You gotta go through whether or not those factors are made for what they bring in. Like that's just the way it works.
Well, Susan, since you're here, I'm curious. One thing that gets me with the codes is we have no restrictions on how many multifamily units you can put on an acre.
I thought there was a units per.
There is not.
There is
There's
not.
not.
There is not. The only thing
Because I
that,
thought that was one of the issues with the battery project, the one on 7th Street behind the liquor store.
no, there is no issue. There is no number. The only number there is if you build something that's multi-use and you have I say, what's it, you have retail or something on the first floor. The second floor, you limit it to 10 residents per
Oh,
acre.
mixed use,
And that's it. That's it. That's the only limit there is on the number of residents you can do per acre. I think that's something that should be cleared up.
well, potentially that's something we need to put
So,
some max on, yeah, to develop.
Oh, just one more thing to your list, Matt.
but you want me to write you an email about that, or is this good?
Yeah, why don't you guys
Yeah,
discuss that offline?
That's why she had her there. I wanted that one day.
Right.
That's all.
So,
I want to go.
so this is a good teaching moment, just so you're aware, right? You're talking, Suzanne, about this issue, right? And somebody heard you say that, just heard, and it's on the tape, so it's fine. So, and it was fine, what you did is fine, but let's assume you just said, and you added, and I think we ought to severely limit the use of apartments. Let's say you would have said that, which you didn't. Somebody's gonna come in the next time you have an apartment and say, you have a bias against the apartments. Right? I'm just, you gotta be careful. And I was listening and there was nothing wrong with what you did, but I'm trying to use that as an example of, see how that can burn you really quickly? Even in a
If he
conversation.
had.
Well, what if I send her an email saying what I think it should? Is that a bias then too?
I think I need a
Just
motion
approval.
to adjourn.
And certainly subject to FOIA. And is it a bias? Probably not. I would not disqualify you.
So I'm not gonna give her a number. I'm gonna say, you guys should come up with a number.
Well, that's fine.
Yeah, but if I gave her a number, it probably makes it a different animal, right?
It might, it might. The worst thing that I have to deal with is disqualification questions. They stink. And when I do disqualification stuff, I look at the case law on it. And then I have to do, what would the Public Integrity Commission think? How would they do this, right? Because I know if we make a mistake on the disqualification issue, hates the whole board. It's terrible. I hate those. So I'm here today to train you to not get me into disqualification issues. So I don't have to deal with that because it's the one thing I hate the most.
Can I have a motion to adjourn, please? All in favor?
Aye.
We got a public comment?